New Judy Sage.
Tanaka, Mr Speaker, thank you. Well, it's a very long time since I did land law at university, and it was quite an interesting exercise being part of the Government Administration Select Committee and taking another look at those fundamental principles of our land registration system. And do congratulate the very Ruth Dyson, Honourable Ruth Dyson, as chair of that committee, for the very collegial way in which it was chaired, and I think that's why we're seeing a fair degree of unanimity on the bill, though New Zealand First may differ. And I think the bill, as others have said, is a modernisation, a simplification, a bringing of the paper-based registration system into the digital age, in recognition that now our land transfer system, our registration system, is done electronically. Unlike places like Australia, where I understand there's still a fair degree of paper-based transfers. But it is a big bill, it is a substantial bill, but those principles of the Torrens system stay intact, and they are that the register of lands that describes and records the ownership of estates and interests in lands is found in the one place, it's accurate so that people don't have to go elsewhere to find out the key facts relating to title, and that that register provides security of ownership. That indefeasibility is a fundamental part of that, so once a transaction has been registered, it can't be set aside except in the case of fraud. And of course it's this certainty that allows people to have transactions involving land with a degree of certainty that they are doing it, they're buying land which they understand they can buy, and that those are properly registered, and of course that the state guarantees the accuracy of those transfers and of those rights, and that there will be compensation if there's been an error in the way that the system operates. As others have said, there were quite substantial submissions from bankers looking at the clause 54, I think it was, and pointing out that those changes in relation to mortgage fraud, where someone was pretending to be the mortgagor or to have the authority of the mortgagor, and the requirements around verification of identity were going to create major compliance costs for the banks, and that they were in fact going further than the identity verification rules in other legislation. And that there is already in the system of e-dealings quite robust identity standards on conveyances, and that currently banks rely on solicitors, rely on the conveyances, and that these new requirements which were originally proposed would have significant compliance costs, because the banks would be needing to double check what the conveyancers had done. So that those submissions were quite convincing, and I'd like to acknowledge the Minister here, who actually let the Select Committee get on with its work, consider the submissions and make a decision here, rather than taking that authority, as we see with a number of other bills, being done by the Minister, rather than allowing the Select Committee to make a choice. One of the other areas where there were a lot of submissions was from around the issue of legal executives, and the Institute of New Zealand Legal Executives calling for fellows of the Institute to be allowed the authority to certify instruments for registration where they were undertaking that work under the supervision of a lawyer. And I think there will be a number of disappointed legal executives, because it was the committee's decision, even though there are a lot of submissions supporting the legal executives from a number of law firms, that what was required here was actually a change to the legislation around lawyers and conveyancers, that employment legislation, professional legislation, rather than to this bill. So it was seen as an issue that was outside the scope of the bill, and the lawyers and conveyancers legislation should be amended instead. One of the other issues was around manifest injustice and the concerns of the Law Society and others, while recognising the importance of providing compensation where there had been an error in the operation of the registration system, ensuring that this was very clearly defined so that you didn't get undermining of indefeasibility by giving the court a wide power to undo registered ownership. And here the advice of officials was that the case law showed that there was a very high threshold to allowing situations of manifest injustice and allowing compensation, and that the legislation the Select Committee actually tightened the provisions here. So it does have a very high threshold so that concept of indefeasibility is protected. So it has been, Mr. Speaker, a very technical bill, and like others would also like to encourage the government to deal with the major issue in this area of land transfer, which is sales of land to overseas investors. Because the government has really been sitting on its hands here. It's been pretending that business as usual is continuing, when that's not the case, when we've had the major collapse in dairy payouts and the effects of this on a debt-ridden industry. And with the high level of debt in the dairy sector, with dairy payouts going so low, with the Reserve Bank predicting that up to 44% of dairy farm loans with an industry which has got a debt liability of around $48 billion, 44% of those loans being non-performing, then what will happen? People will want to quit their properties, so New Zealand is facing the prospect of a double disaster, not only the dairying slump flowing through to the rest of the economy, but also the government's very lax rules on the sale of land to overseas interests, meaning that we are at risk of large tracts of very productive land being sold off overseas. So National's dairy strategy has been not only a personal disaster for a lot of families as well as the environment, not only putting families at breaking point, but it's going to be a long-term disaster for our country if we lose a lot of land to overseas interests. And the government's got to take responsibility for this, because while LINZ leads in terms of our land transfer system, the registration system, the land online, the electronic transfers, here, the other part of LINZ, the Overseas Investment Office, is totally hopeless. And we need a major law change to rule out the sale of productive land overseas. They've done that in China, in Switzerland, in Canada, in Argentina, in Thailand, in Japan, in Ireland and India. But we don't do it in New Zealand, so the government needs to change the law so that we can get overseas investment through long-term leases rather than the sale of productive land. So that is the major change to our land transfer system that we need to follow on the heels of this one, but under this government we're not going to get that.
A question? Yeah, sorry.